A blessed afternoon to all the administrators, faculty, and personnel of the CEAP member schools all over the Philippines. I am Christine Marie Lesaca Saludes, principal of Miriam College Grade School. I am so honored to be your moderator this afternoon. Welcome to the third day of our 2021 CEAP Congress with our theme Presence as Presence, embracing our evangelizing mission by inspiring, witnessing, and sanctifying. Let us begin our session with an opening prayer as we remember that we are in the holy presence of God. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. Heavenly Father, thank you for the honor of being a Catholic educator, and thank you for the children under our care. We know that they are gifts from you. Daily, we need your strength and wisdom to guide them in the way they must go. Give us patience and a joyful heart. Let us be examples of your love and forgiveness. Help us to be the best we can be. We pray that your Holy Spirit will teach us, that your wisdom will guide us, and that your love will move us in bringing our children, your children, closer to you. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. Good afternoon once again. For those who just tuned in with us, we hope you had a good lunch. And we welcome you to the first afternoon session of day 3 of our 2021 CEAP Congress. We are live both on the CEAP Facebook page and the CEAP channel on YouTube. Before we begin, allow me to give you some reminders. First, as the talk is ongoing, we encourage you to post your questions or comments at the comment section on Facebook and YouTube, and we will ask these questions or read the comments during the Q&A portion. Second, we do get a lot of queries about certificates. Please be informed that you will receive the certificate of attendance only upon completion of the evaluation form. The link has already been posted as part of the caption of this video, both on YouTube and Facebook. But please note that the link will only go live right after this session until 7 p.m. today. So if you click now, it's not going to open yet. We encourage you to answer the evaluation form, and you will receive your certificate of attendance within 3 to 5 days. As in all our previous webinars, the registration to the Congress is also free. But if you wish to make a donation to help defray our expenses in staging this Congress, or to the Kapatiran Kamagong Fund to help our small mission schools, you may donate them or deposit them in the bank account flashed on our screen. You may also send us some stars. And we also thank the schools who donated as they registered in this Congress. Thank you very much for your generosity. Lastly, we encourage you to share this webinar to your networks using the hashtag CEAP I love CEAP, and I love Catholic Ed. Let me now introduce our session for this afternoon on legal updates in education. Our resource person for this session is the esteemed Attorney Sabino B. Padilla IV, Legal Counsel of the CEAP.
Good afternoon. I am Attorney Sabino Padilla IV, and I will be sharing with you some relevant regulatory law updates, relevant especially during this continuing pandemic. I understand that you might be having your lunch. If you're having it, please continue. Our brief discussion will take us through some labor law matters, tax matters, local tax matters, and various odds and ends. And I won't make this a very long lecture so that we will have a longer Q&A after the lecture. No? So let's begin by looking at some history. You will recall that in January of 2020, the most important event in the Philippines was the eruption of the Taal volcano. This was in January. And on that basis, the Department of Labor issued Dole Labor Advisory number 1, which granted employers in the private sector the prerogative to suspend work to ensure safety and the health of their employees during a natural or man-made calamity. In this same labor advisory, the Secretary of Labor reiterated the no work, no pay rule, unless there was a favorable company policy practice or CBA provision. Little did we know that 2 months after this advisory was issued, there would be this great pandemic that caused the lockdown of the whole country. Now, after labor advisory number 1, as you know, there was that this pandemic began, and the Department of Labor had to issue several labor advisories. I don't have to go over all of them. You are aware of them. Let me just show you, just refresh you on some of the more pertinent ones. Dole Labor Advisory number 9 provided the guidelines on the implementation of flexible work arrangements as remedial measure during the ongoing COVID-19 outbreak. Flexible work arrangements include reduction of work hours, rotation of workers, forced leaves, etc. This was supplanted later on by Labor Advisory number 11. And later on, the DOLE and the Department of Trade and Industry issued interim guidelines on workplace prevention and control of COVID-19. Let me remind all of you that these interim guidelines are still in force. And if you do have a blended work arrangement now, you are supposed to continue with the safety measures provided by the DOLE DTI joint guidelines. Now, DOLE Labor Advisory number 17 and its progeny is a very important one because it encouraged work from home or telecommuting work arrangements or alternative work schemes to prevent termination or closure of businesses. Advisory provides that employers and employees may agree voluntarily and in writing to temporarily adjust wages and wage-related benefits as provided for in existing employment contracts. The adjustment shall not exceed 6 months, and after such period, employers and employees may renew their agreement. The advisory also provides reportorial requirements to the DOLE, where we are to submit to the DOLE regional office having jurisdiction over the principal place of business of the employer such copies as the alternative work arrangements. And of course, later on, if there will be terminations or a reduction in work hours, there is a reportorial requirement that has to be completed and submitted to the DOLE. That is the significance of this Labor Advisory number 17, as well as the amendments or supplements thereto. Labor Advisory 17-B, on the other hand, provided that there is no grievance mechanism for any disagreement as to wages and other benefits, the matter shall be referred to the regional branch of the NCMB of the DOLE, which has jurisdiction over the workplace for conciliation. Similar to controversies involving wage-related benefits or wage standards, no, are present today. So nothing really earth-shattering there. But you will note that going back, Labor Advisory number 17 provides the rule, no, that changes in salaries and other terms and conditions of work have to be put in writing, and this can be in contracts that last for 6 months. In fact, that's the ideal. If there is a need, and most of you, if not all of you, have experienced the need to execute new contracts, new 6-month contracts, then so be it. You have to do that too. Okay. Labor Advisory number 18 is significant because it provides that the employer shall shoulder the cost of COVID-19 prevention and control measures, such as but not limited to testing, disinfection facilities, hand sanitizers, personal protective equipment, etc. And the last significant labor advisory I want to take up is Labor Advisory number 3, series of 2021. Here, the DOLE orders covered establishments and employers to adopt and implement appropriate vaccination policies in the workplace as part of their occupational safety and health program, consistent with the guidelines issued by the DOH and the IATF. No cost of vaccination in the workplace shall be charged against or passed on, directly or indirectly, to the employees. And there is that no vaccine, no work policy is prohibited. Now, at present, this might be the most significant labor matter, no? Because the government has ramped up vaccination. The Department of Education now has certain pilot schools where face-to-face education will be resumed. But there is still the question of whether there is a mandate that only those who have been vaccinated may teach, and or only those vaccinated may enroll and partake of face-to-face learning. The flip side of that is if a person who is not vaccinated may be compelled to attend classes. The position of the government now is that you cannot compel students to enroll if they do not want to because of this pandemic. There is no one is forced. And in terms of employees, you cannot discriminate against unvaccinated teachers or non-faculty staff by refusing to, at the very least, put them back in the payroll. No? That is my reading of the present government policy. Now, what happens if the government decides that the rollout of vaccination is so slow and it needs to compel vaccinations? Now, that is an interesting question. In the United States, that will probably be elevated. That issue will probably be elevated very soon. there were two cases involving state universities where the schools expressly stated, one was in Indiana and I think another was in New York, where the schools stated that they would not accept any employee or any student that had not been vaccinated. The cases reached the federal district courts of appeals of these two jurisdictions, and the both federal district courts of appeals ruled that the schools had the right to do so. The matter of the Indiana school decision, as far as I know, went to the Supreme Court of the United States, but the Supreme Court of the United States refused to take on the case. This is significant because it appears that as far as the Supreme Court of the United States is concerned, that is a state matter, and in all likelihood, the justices believe that there was a police power interest of the state to uphold the school's prerogative not to accept people who were not vaccinated. Now, in the United States, this is not really a novel issue because as early as 1905, in a case involving the city of Cambridge, that is where Harvard University is located, there was an ordinance passed by the city of Cambridge, making it mandatory for its citizens to be vaccinated against smallpox. There was a smallpox epidemic, as you will probably note, around the year 1900. The penalty for persons who refused to be vaccinated was a penal fine. Hindi naman imprisonment, penal fine. Nevertheless, one aggrieved party decided to test this before the courts. And the US Supreme Court in 1905 said that the city of Cambridge had every right to impose this measure because it was a police power measure and it was necessary for the protection of public health. So perhaps that could also be how our Supreme Court will decide should a similar case reach our courts. So I am sure that all of you are very well versed already with labor regulatory rules during this pandemic. It seems that this will not be over, at least for the next school year. So we have to continue following these labor advisories. And of course, following the safety measures imposed by the state. Social distancing, wearing of masks, frequent washing of hands, etc. Now let me go now to the National Internal Revenue Code. I'm sure many of you have been recipients of letters of authority or maybe even assessments from the BIR even during this pandemic. It is within their right to do so with respect to non-stock, non-profit educational institutions. It is the right of the BIR to see whether the revenues and assets of these non-stock non-profit institutions are used actually directly and exclusively for educational purposes. That is the standard by which schools can claim that they are exempt from taxes and duties under Section 4, subparagraph 3 of Article 14 of the Constitution. Now, you will note that the particular provision of the Constitution says that for non-stock, non-profit educational institutions to be exempt from taxes and duties, their revenues and their assets should be used. The significant word is used, actually directly and exclusively for educational purposes. Before the 1987 Constitution, there was always that question whether the exemption of schools at the time before the 1987 Constitution, schools were still taxed at the preferential rate of 10%. But even then, the courts had to determine whether this preferential rate would be applied to the assets and revenues of schools that were not sourced from purely educational purposes. And then the 1987 Constitution was approved and ratified by the people. And we have this new section where it's not only a preferential rate, but a full exemption, provided that, as I said, the revenues and assets are used actually directly and exclusively for educational purposes. So even after the 1987 Constitution was passed, the BIR would always look at the source of the revenues and assets. So the BIR would say, uy, meron kayong fast food center sa eskwelahan ninyo. Yung source niyan, hindi naman education. No? So I will tax that. But this runs counter to the constitutional provision because what is important is not the source, but the use, the destination of the revenues of the school. And if the destination is to some activity that is exclusively, directly, actually for educational purposes, then the revenues, the income of the school should be tax-free. Now, during the time of President Ramos, the Department of Finance issued DOF Order 14995 that required schools to set aside their educational income and utilize the same for educational purposes. The implication there was that if you did not utilize the same for educational purposes, then that income would be taxed. No? So that is why we have advised schools, no, that at the end of the year, their various boards of trustees should issue board resolutions saying that if we have a surplus, no, this surplus is being earmarked for purely educational purposes. And it would be ideal if that board resolution stated what those educational purposes are. For example, faculty development or a capital development for the construction of a gym or a new library, etc. This earmarking through a resolution is important especially if you have, of course, surplus income, because it will give the school a reason to say that we have earmarked these funds, and these are intended to be used exclusively for educational purposes. And as you can see, this income is earmarked. We're not using it for any other purpose. So please bear that in mind. No? You have to follow strictly DOF 14995. In fact, even if you're not sure whether you have surplus income at the end of the year, you still make that board resolution. That gives you an added protection. Now, most of you are probably aware of the decision of the Supreme Court in Commissioner versus De La Salle University, where the Supreme Court once and for all interpreted Article 14, Section 4.3. And the Supreme Court said that, as I had already discussed earlier, that this section of the Constitution does not require that the revenues and income must have been sourced from educational activities or activities related to the purposes of an educational institution. So it need not be sourced entirely from tuition fees, no? Or miscellaneous fees. No? The phrase "all revenues" is unqualified by any reference to the source of the revenues. Thus, so long as the revenues and income are used actually directly and exclusively for educational purposes, then said revenues and income shall be exempt from income tax and duties. Now, I'd like to add too that aside from exemption from income tax and duties, this includes the so-called local business tax, the local business tax to the local government, which we will discuss a little later. Now, what has been happening even after the De La Salle ruling is that the BIR has zeroed in on educational institutions, and precisely they're looking for income that is not used for education, that they say was not used for educational purposes, and that income they charge for deficiency income taxes, VAT, and what have you. So that has been happening to so many of our schools. Now, how do you counter that? Now, the best, of course, is through a very convincing documentary exhibits, documents that will show the trail from the source of the income to the particular use. That is always the best. So you will have to, your internal auditors or your finance people have to work very closely with your external auditors so that you know what documents are needed to match. The technical word is match, to match your revenues with the educational activity. Now, one clear example of the matching was the case of Ateneo versus Commissioner, which was a Court of Tax Appeals case. This case went to the Supreme Court, but the Supreme Court refused to reverse or even entertain the case. Now, how does one prove that revenues and income are used actually directly and exclusively for educational purposes? In the Ateneo case, Ateneo was able to show this when it submitted, as you will see in the slide, summaries of contribution and expenditures for the fiscal years involved, the audited FS, and documents which showed, which consisted of salaries and other related expenses, employee benefits, utility supplies, scholarship and financial aid, faculty development, program development, other expenses allocated to school units, etc., scholarship grants, financial assistance, and research expenses, provision for doubtful accounts. Both the external auditor of Ateneo and the internal finance officer testified in this case. And because they were able to match entries that were earmarked in their general fund with these particular expenses, the Court of Tax Appeal said that Ateneo was able to successfully show that the concession fees that were the subject of this case were used actually directly and exclusively for educational purposes. Now, as I mentioned earlier, this case, the provision of the Constitution also applies to local governments. So please keep that in mind. The other tax matter that you have to take note of is on prohibited inurements. Inurements in a general sense means benefits. The BIR is very strict on this. They say that for an entity to qualify as a tax-exempt, non-stock, non-profit corporation, its earnings or assets shall not inure to the benefit of any of its trustees, organizers, officers, members, or any specific person. And that RMC of the Revenue Memorandum Circular of the BIR said, listed prohibited inurements, prohibited investments. They are prohibited in the sense that they destroy the tax-exempt status of the non-stock, non-profit corporation, including a non-stock, non-profit educational corporation. Now, what are these inurements? Payment of compensation, salaries and honorarium to its trustees or organizers, payment of exorbitant or unreasonable compensation to its employees, providing welfare aid and financial assistance to its members. Letter D, which is quite crucial for us in the educational sector, donations to any person or entity, except donations made to other entities formed for a purpose or purposes similar to its own. Now, the BIR, let me zero in on letter D. The BIR has been very, very wary of contributions made by schools to their mother congregations. This is what they're looking into. They do not like a school which in reality is an instrumentality of the congregation to give any part of its revenues to the mother house, the mother congregation. That is a prohibited inurement. The exception is donations made to other entities formed for a purpose or purposes similar to its own. So what is not prohibited is a donation made by a school that's part of a congregation, to another school that is controlled by the congregation. So De La Salle University Manila can donate ostensibly to De La Salle Dasmariñas. That's an example. No? You can think of any other example, no? But that is not a prohibited inurement. Another prohibited inurement is purchase of goods or service in amounts in excess of the fair market value of such goods or services, or from an entity in which one or more of its trustees, officers, or fiduciaries has an interest, etc. No? So these are the things that the BIR examiner will try to look into when examining your books. No? Prohibited inurements. And if they cannot find this inurement, then they will look at other stuff like withholding taxes. Have the proper taxes been withheld and remitted to the BIR, or DST issues? No? So that is the common items that examiners look into when examining the books of account or the financial statements of various schools. In relation to this, you will recall that during the time of Commissioner Henares in 2013, she issued RMO 20-2013, which required all non-stock, non-profit corporations, including schools, to have their tax-exempt rulings revalidated to continue the tax exemption. And this was good for only 3 years. In 2016, the Duterte administration revised this RMO under RMO 44-2016, which removed the non-stock, non-profit schools from the coverage of 2013, but nevertheless required them to still get a revalidated tax-exempt ruling or a new tax-exempt ruling for new schools, but with less documentary requirements. So a school now is faced with the question, especially those schools that had already obtained tax-exempt rulings before 2013 or before 2016 for that matter. We have this old ruling, maybe issued in the 1990s or early 2000s, the decade of 2000s, that says that we are a tax-exempt school. Do we have to get a revalidated ruling? Our position is, legally speaking, academically, if you look at it purely on a legal point, from a legal point of view, you are not required to get this. But some schools say, well, if we do not get this tax-exempt ruling, we cannot issue official receipts, which is another issue. Or when we are being audited, that is the first thing they look for, the revalidated ruling and our certificate of registration. So our position is, because there's already a constitutional provision granting you tax exemption, you cannot water down that constitutional right via a administrative fiat. But we always tell our clients, it is really up to you. If it's for your convenience to get that ruling, then get it. Now, for those who get the tax-exempt rulings, you will note that the BIR has a template for schools. It exempts income tax only on the following revenues or receipts: tuition fees, other related educational income, income derived from operations of cafeterias, canteens, and bookstores located within the school premises, provided they are owned and operated by the school as ancillary services. This also includes, by the way, dormitories, provided they are located, owned and operated by the school, located within the school premises, and are operated as ancillary services. You will note that the template itself does not follow the Supreme Court decision in De La Salle, because what is important is not the source, but the destination, as the Supreme Court said. So you may have bookstores that are not owned by the school. You may have a national bookstore within your campus. You may have a McDonald's or Jollibee or a Kentucky Fried Chicken in your campus. And the rental income you receive from them should not be taxable so long as the revenues are used actually directly and exclusively for educational purposes. But if you look at the BIR template, if you get your tax-exempt ruling, this rental income is taxable. So that's really the problem there. If the BIR says, may renta ka dito, I will tax you, sasabihin mo, teka muna, pero nakita mo yung renta ko dito, I used it purely for scholarships. Tama yung school based on De La Salle, but as far as the BIR is concerned, then I will assess you. Then you will have to go to court, and you will probably win, So there's something quite odd, with the position of the BIR. If you think about it also from a purely academic point of view, while the BIR exempts cafeterias, canteens, and bookstores located with the income from cafeterias, canteens, and bookstores, and dormitories located within school premises, provided that they are operated by the school as ancillary services. What happens in reality is that when the BIR sees that there is a canteen or a bookstore owned and operated by the school, it doesn't anymore look into whether the revenues are actually used for educational purposes. So in all, it is entirely possible for a school to use its cafeteria income, its bookstore income, for a purpose other than education. And if you follow the template, okay lang yan sa BIR, which is also against the De La Salle ruling. So those are some problem areas you face when you get your tax-exempt ruling under the present dispensation. Now, over the past 2 years, the BIR, the national government has come up with laws, has signed laws that have granted tax amnesties. Now, these amnesties have already expired, except for the amnesty on estate taxes. This was extended by 2 years, under the CREATE law. So we will not go too much into tax amnesties already. Now, earlier, I mentioned that the De La Salle ruling also covered local business taxes. So normally, a local business tax is assessed on the basis of gross income. Some local governments, and they have the right also, have investigated schools, and then they see that they have this income from tuition fees, and they say, I will tax you a business tax. That is wrong under the De La Salle ruling. But then, to be safe, the schools has to show that the tuition income it received, again, was used actually directly and exclusively for educational purposes. So your accountants, your internal and external accountants have to also be prepared to show that. Now, every year, every January, February, we receive a query. Do we have to pay the mayor's permit fee? Now, the Bureau of Local Government Finance, as early as 2013, said that you have to pay the basic mayor's permit fee. Typically, this runs from between 500 to, let's say, 1,000 or 2,000 pesos. The Bureau of Local Government Finance said that the exemption from taxes does not carry with it the exemption from the payment of fees for regulation, inspection, surveillance, and service rendered by a local government unit. So you have to pay the basic mayor's permit fee. But if you see that what they say as basic mayor's permit fee includes a business tax component, then you can refuse, because you are not required to pay the local business tax. With respect to other regulatory fees, like sanitation permit fee, electrical inspection fee, etc., each local government has similar regulatory fees imposed, and some have peculiar ones. The basic rule is that the fees or charges must be commensurate with the cost of regulation, inspection, and licensing. So if they base their assessment of a regulatory fee, again, on the basis of number of students, on the basis of income, this is not correct. And the fees have to be commensurate and reasonable, commensurate with the cost of regulation, inspection, and licensing. That can be a little tricky because sometimes you say X amount, mukhang reasonable naman, let's pay it na. But sometimes it can really be very exorbitant. Because if a regulatory fee is exorbitant, it becomes a tax. And you are not required to pay a tax. So that is something that has to be discussed with your counsel, and to see whether the fee is reasonable or not. If it is unreasonable, then chances are you can pay, but pay under protest and go through the procedures of questioning that assessment. And sometimes it might end up in court. So those are some tax matters that you have to be aware of, especially since we will be paying, we're close to 2022, and you will be getting your permits very soon. Now, over the last year or so, We've had also queries on intellectual property, no? Particularly modules created by with the assistance of faculty members. Now, under section 178.3 of the Intellectual Property Code, it is provided that in the case something is created by an author during and in the course of his or her employment, a copyright shall belong to A, the employee. The creation of the object of copyright is not part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. And B, the employer, if the work is the result of the performance of his regularly assigned duties, unless there is an agreement, express or implied, to the contrary. We've had queries on whether a teacher, let's say a biology teacher, very talented biology teacher, if that teacher during regular time in school creates a workbook for music, for instance, who owns the copyright for that creation? And under the law, it's the employees, no? Because that was not done in the performance of his regularly assigned duties. No? But if the biology teacher were to create a module for his or her department, no, for use of the school, no, then that is not his ownership. No? That is owned by the school. Unless you have an agreement with the teacher, with your teachers, to the contrary. So that is the rule to be followed. The other regulatory, of course, concerns are the SEC concerns, no? With respect to the submission of annual reports. No? You are aware, of course, because I'm sure most of you have submitted your annual reports already. This should be online using the Commission's online submission tool, or OST. These include the audited financial statements, the general information sheet, the sworn statement for the foundation, the general form for financial statements, the special form of financial statements for certain corporations, the affidavit of non-operation, and the affidavit of non-holding of annual meetings. So this has to be done online. No? And there are, as you will note, kiosks that were set up by the SEC, no, to assist you in complying with these requirements. No? So the name of the game now is that we should be well versed with the submission and filing of documents online. Now, I had the privilege of speaking to the CEAP Region 7 convention a couple of months ago. And I got to discuss with them, among others, the World Bank report on the crisis on Philippine education, no? And the NEDA report on the effects of the pandemic on our educational system. The reports are sobering, in fact, quite disturbing, no? Because in the case of the World Bank, there was a finding that there is an unacceptably poor school climate with high levels of bullying. No? And one key recommendation, there were many recommendations, was to promote safe and inclusive learning environments. The World Bank also advised Philippine schools to address the bullying incidents that is taking place at an alarming level and campaigning for a bully-free school, for bully-free schools nationwide. The NEDA report, on the other hand, talked about the economic effects of these prolonged lockdowns. No? Anyway, the long and short of it is that for the good of everyone, we need to have face-to-face classes as soon as possible. Now, but whether or not we have face-to-face classes, we still need to protect certain vulnerable elements of our school system. Children, women, and of late, no, the state promotes protection to the gay and lesbian community, the trans and transgenders. In my talk before the Region 7, we talked about Department Order number 40, the DepEd, no? Which pertain to protection of children. There's a need to protect them from psychological violence, from harassment, which has been on the rise, and because of the technology, we have to protect them from cyberbullying. Cyberbullying has become a very, very prevalent malice in our school system and also in society as a whole. The recommendation is that we should ramp up our child protection committees in our various schools. We should have a code of conduct, which should be ideally put in our manuals. And of course, our child protection committee should meet regularly and see how they can address the issues of cyberbullying. Now, with respect to the use of technology and digital, various digital devices, which is again prevalent among our children, we have to advise them on good cyber citizenship. And schools have been asked by the Supreme Court itself, no, to include good cyber citizenship and digital literacy as part of our educational system. No? Now, the advice of the Supreme Court came through its decision in the case of C.O.N.G.R.E.S.S versus St. Teresa's College of Cebu. I'm sure you're also familiar with that. This involved these two students who, in Cebu, who were about to graduate, and then they had their pictures taken with their cameras, you know, scantily dressed, and they were drunk along the streets of Cebu. And these were posted and uploaded in Facebook. Anyway, the long and short of it is that the school authorities, as a sanction, did not allow them to march because they were graduating. The students, graduating high school seniors, sued the school for writ of habeas data. We will not go over the procedural aspect. But the case was dismissed because the judge said it's not the fault of the school. You uploaded this voluntarily, no? But then the student said, no, but we said it's only available to our friends, no? But your friends scattered these pictures, no? So the Supreme Court said that online social network users should be aware of the risks that they expose themselves whenever they engage in cyberspace activities. Accordingly, they should be cautious enough to control their privacy and to exercise sound discretion as to how much information about themselves they are willing to give up. Internet consumers ought to be aware that by entering or uploading any kind of data or information online, they are automatically and inevitably making it permanently available online, perpetuation of which is outside the ambit of their control. More importantly, information that is otherwise private, voluntarily surrendered by them, can be opened, read, or copies by third parties who may or may not be allowed access to such. And the court ended by saying, equity serves the vigilant. Demanding relief from the courts, as here, requires that claimants themselves take utmost care in a right which they allege to have been violated. So we have to teach our children in schools good cyber citizenship. In my lecture to Region 7 of the CEAP, we also talked about protection of women, no, under the Magna Carta of Women, no, because there is a lot of cyberbullying also that happens, no, to them. No? But we zeroed in also on the provision of the Magna Carta, which provides that expulsion and non-readmission of women faculty due to pregnancy outside of marriage shall be outlawed, and no school shall turn out or refuse admission to a female student solely on account of having contracted pregnancy outside of marriage during her term in school. This was tested in the case of Leius versus St. Scholastica's Westboro. We handled that, my firm handled that for St. School. We had won in all the lower courts except at the Supreme Court level. Because the Supreme Court said the school did not have the right to terminate the employment of the teacher involved, no, who had gotten pregnant out of wedlock because the teacher and her partner had no impediment from marrying each other, no, even if this violated the policy of the school. The court went on to say that premarital relations between two consenting adults who have no impediment to marry each other and consequently conceiving a child out of wedlock, gauged from a purely public and secular view of morality does not amount to an immoral or disgraceful conduct under Section 94E of the Manual of Regulations for Private Schools. So in situations like this, the Supreme Court said, you have to view it from a purely public and secular view of morality. Public and secular view of morality. That is the standard. Now, some of our clients have said, okay, that's what they say. What we're going to do is we are going to put it in our contract expressly that under the Catechism of the Catholic Church, this is considered immoral conduct, etc. Because the Supreme Court in Leus seemed to have given that window for the school to make their policies more clear, because it was, after all, a Catholic school. Some of our clients have amended their employment contracts and faculty manuals, including manuals for non-faculty staff, to make it clear what grossly or immoral conduct is. I have advised them, and we have advised them, that this is still a live issue. It has to be tested in court. So that is where we are as far as that matter is concerned. Finally, I want to call, before we have our question and answer, I want to call your attention to Republic Act 11313, which was signed in 2019, which defines gender-based sexual harassment in streets, public places, online workplaces, and educational or training institutions, and providing protective measures and prescribing penalties thereof. This is known as the Safe Spaces Act of 2019. Now, this was came in force shortly before the pandemic, so there has really been no test case on this matter. But this is an extension of the sexual harassment law of 1995, because this one zeroes in on streets, public places, workplaces, and educational or training institutions. The first sexual harassment law was very generic. This is here they zero in on certain public places, including schools and training institutions. So there, the law has a separate section for schools and training institutions. So under the Sexual Harassment Act of 1995, schools are supposed to have what they call a CODI, Committee on Decorum and Investigation. This law on the Safe Spaces Act emphasizes that this CODI has to be more active in handling sexual harassment cases, particularly cases that violate this act. And the act includes covers specific acts that are not covered in the first law. So if, for instance, it covers cursing, wolf whistling, catcalling, taunting, cursing, unwanted invitations, misogynistic, transphobic, homophobic, and sexist slurs, and relentless requests for one's personal details, including leering and intrusive gazing. So there are really many acts covered by this law, that are very novel. So the school has to have a proactive CODI, Committee on Decorum and Investigation, to learn this and to conduct investigations and to mete out the penalties provided by law. The law specifies penalties for first offense, second offense, etc. The most serious for schools would be expulsion. And the law also, like the admonition of the Supreme Court on good cyber citizenship, the law requires all schools to educate their students from elementary to tertiary level about the provision of the law, this law, and how they can report cases of gender-based streets, public places, and online sexual harassment committed against persons. So there we have it. That is my report for today. I will be happy to entertain questions after this session. And I hope that I was able to give you some information that you will find useful in the coming year. Thank you so much.
Thank you so much, Attorney Padilla, for those updates on labor and tax advisories and the very helpful clarifications on intellectual property, cyber citizenship, and safe spaces, all highly relevant now that schools have transitioned to online distance learning. Your clear message has reached all our viewers in Metro Manila. Good afternoon, Father Tadeo Enrique Balongag and Teresita A. Arcosurot. And warm greetings to our partners who are watching from Cebu, Davao, Osamis, Iloilo, Nueva Vizcaya, Nueva Ecija, Mindoro, Bulacan, Maguindanao, Bohol, Camiguin, Cotabato, and other parts of the country. Greetings to you all. So here are just some important clarifications before we move to the Q&A. Everyone, please allow us to remind you of what our Vice President informed us yesterday in his overview of the Congress. You only need to attend one session for each day for days 3 and 4 and submit an evaluation for one session for each day and the general evaluation on day 5 at the end of the Congress to get an e-certificate for the whole Congress, okay? So please take note of this correction. We will issue only one e-certificate And the requirement is an evaluation of one session from today, one from tomorrow, and the day 5 general evaluation. You may also evaluate the sessions from the virtual Congress Hall. At the program tab of the virtual hall, you can click the button that says evaluate this session. So please do check it out. Okay, so now let's begin our Q&A, Attorney. There are some questions that already came in. We have the first one from Eric and Berda. Good afternoon. How long can schools keep their surplus income, Attorney?
That's a very good question. Ideally, at the end of every year, on the basis of the Department of Finance order that I mentioned in my talk, no, there should be a resolution earmarking the surplus income for particular purposes. If that is not used, it is my position, our position, that can be carried over in the next year, no, and in the year following, provided that the earmarks are clear and specific. No, I'm acutely aware that the BIR will say dapat ginamit mo na kahit ito, no? But that is not correct, no? And that, of course, is subject to interpretation and subject to our regular fights with the BIR, no? But so long as that amount, that surplus, is earmarked, it is our position that that can be carried over, no? Okay. Because you cannot predict when you may have this project that you have thought about, again, because of the pandemic, that's put on hold, no?
That's right.
But once classes are back to normal, face to face, then that project can go through, no? So in the meantime, there's a reason to park those earmarked funds, no? Now later on, it might be the case that there is another maybe more important educational purpose that has to be addressed. Then you have to pass a resolution saying that this amount that was earmarked, let's say for a building X, no, is now going to be used for enhancement of your guidance services or a new building for some other purpose, some other educational purpose, no? That can be done. No?
All right. As long as it's specified. Thank you, Attorney Padilla, for that. There's a question from Patricia Marino. Maybe it just needs to be said, no, after explaining all our provisions earlier. Essentially, are schools not exempt from taxes? They are non-profit institutions. So the clear-cut answer, Attorney Padilla?
A non-stock, non-profit educational institution is tax exempt. That is provided in the Constitution.
All right, that's very clear.
Yeah. Now, there are educational institutions that are called proprietary because they have private shareholders that partake of the profits. No? So these institutions are taxable, no? But they have a preferred rate of 10%. No? Mm-hmm. Now, under the CEAP law, which was passed last year, for the next 2 years, these proprietary institutions will be given a tax break. They will only pay 1% na lang instead of 10%. But that's only for 2 years. But for non-stock, non-profit educational institutions, and I think practically all member schools of CEAP fall under that, we are tax exempt.
Right. Thank you very much for making
that. But the problem is, though, the burden is on us to show that our income is used actually directly and exclusively for educational purposes. So even if we have that constitutional provision in our favor, this does not prevent the BIR from auditing us to see whether that income is actually directly, exclusively used for education. And as I said, it can be earmarked, no? But so long as they see, oh, you're using this, you're going to use this for some educational function, then that's okay.
All right. Thank you. Thank you for that, attorney. The next question is from Sin Cliano. Attorney, good afternoon. Our municipal treasurer made us pay 10,000 pesos for community tax as requirement for business permit or mayor's permit. Is it right, attorney, to pay for community tax? Thank you.
My understanding of the community tax is that it is based, I think, on the number of employees. No, that is a question mark. No, the amount. It also depends on how big a school is, how many employees there are, because 10,000 pesos might be very unreasonable to a small school, but for a huge university with hundreds of employees, it could be reasonable, no? So the test of reasonableness sometimes can be very subjective, no? In my experience, whenever there is a question whether a particular regulatory fee is valid, no, we always go back to the Bureau of Local Government Finance, no, for guidance, no. In various regions, the BLGF has offices, no. So you can inquire, no, whether it is right to impose these regulatory fees or not, no. The standard, as I mentioned in my lecture, is that the fee should be commensurate to the cost of licensing, regulation, supervision. No, commensurate is very relative, also. No, you have in my experience, you have, for instance, some cities and municipalities charging exorbitant, let's say, garbage fees. No. Now that you can question, no? There has to be some rational basis for the imposition of a fee, no, and the rates imposed by the fee, no. If you feel that it is exorbitant, then you question it, no. As to the community tax, generally you cannot impose a tax, no. So that in itself can be questioned, no?
Right. They can ask for clarification.
Yeah, it should be a fee. It cannot be a tax. If a regulatory fee is so exorbitant, the rule is it becomes already a tax, and therefore that can be questioned.
And that will be determined by the size of the institution as well, no, attorney?
That is one factor that is used, no?
Right. Okay.
But go back to the general rule, no? Non-stock, non-profit educational institutions are exempt from all taxes and duties, no? Now, but they have to pay regulatory fees to the local government. That is the rule, no? Now, if a regulatory fee is so exorbitant, it becomes a tax, and therefore it is illegal. No? That's the basis for your questioning.
All right. Thank you. So we hope that Sin Cliano is guided on how to probe into this more. On a related note, Arnel Cadelinia is asking, okay, this is a situation, Attorney Padilla, if we allow Jollibee, for example, to operate a kiosk inside the school, documented the revenue as for scholarship, okay? How can we respond if the local BIR will still insist on paying taxes of the Jollibee kiosk?
Well, you question them. You have to fight them.
All right.
That's unfortunately that's what we have now, no? As I mentioned in my lecture, the De La Salle University rule of the Supreme Court decision clarified many things, no? Because these big universities, La Salle, Ateneo, UST, they all have these concessionaires, no? Now, so long as you can show that the rental income you get from these concessionaires, again, is used actually directly and exclusively, is tax exempt, no? But the problem with the BIR is that despite all these decisions of the Supreme Court, they still think of the source. The source has to be education-based, no? Not business-based. No? In fact, we had a philosophical discussion once with the chief of staff of Commissioner Dulay, no? Before the La Salle decision came out. No? He was saying, if Ateneo de Davao, he was giving an example, no? Had a bingo hall, no? And they have bingo events every week, no? That is taxable, he said, no? But if you look at the De La Salle ruling, your income there, so long as you say it's been used, you show via clear documentation then that income was used for scholarships,
purposes,
etc., faculty development, no? And the matching has to be clear, then that is also tax exempt, no?
Right. We need the paperwork to prove that.
Yeah, that's why, as I said, your finance people in the school have to really work in tandem with your external auditors, no, to make sure that your documentation is clear.
That's right. Thank you, Attorney. Another question from Alan Gascon. Good afternoon, Attorney Padilla. Are we obliged to pay taxes if we have no certificate of tax exemption issued by National BIR, even if they know that we are non-stock, non-profit institutions?
Oh, that's also another cause of friction, no, between the BIR and our schools. No, if you look at the Constitution, so long as you are non-stock, non-profit educational institution, no, you are clothed with this tax exemption. No, you do not have to get a confirmatory ruling or a confirmatory order from the BIR that says you are tax exempt. No,
I see.
Normally you just show your articles, your bylaws, your license from the CHED or the DepEd. That will show
that will be sufficient.
That should be sufficient. No? And there are revenue officers who will consider that sufficient. No? They will not harp on that anymore. They will just look into your books and see whether you have income and if it's used actually directly and exclusively. But there are some revenue examiners who are very lazy. They say, "Oh, you have no tax exempt certificate. Therefore, you are taxable. Therefore, we're going to assess you." No. Now, unfortunately, that's where you have to fight them. No, you have to get your counsel. You have to contest it. No. Of course, if you don't want to be bothered so much, then you can also go to the BIR and secure a tax-exempt ruling under Revenue Memorandum Order 44-2016. No? And once you get that, you go to your, that's issued by the National Office for Schools, no? In Manila. And once you get that, you go to your local RDO and get a tax-exempt certificate. No? That's how some schools have done it. No, it's their prerogative. No.
Yes.
But it's for as far as we're concerned, it's not necessary. No? In
Okay.
fact, as I mentioned in my lecture, there is a template from the BIR that says the only income that's exempt are tuition fee income, income from bookstores, canteens, and dormitories within the campus. No?
Within the campus. Opo.
Yeah. So in effect, it doesn't even follow De La Salle because in De La Salle, you can have other income. And that other income should also be tax exempt, provided again, you can prove that it's used actually directly, exclusively for educational purposes. So there's a defect also in the ruling that they issue. No?
Okay.
It's a lot narrower than what it should be.
Okay. Thank you very much. So for as long as it's indicated in the bylaws that they are non-stop non-profit, then they can fight that. No, they can fight that.
Yeah, they should.
Okay,
They can. No? They can
All
fight.
right. All right. Thank you, attorney. There's another question here. This time it's related to salary. So the question of Miss Monica Navarro is it justifiable to increase yearly the salaries of the employees, even if enrollees are going down? The numbers are going down and the financial operating budget is in deficit. Is it justifiable to increase the salaries of employees yearly?
Well, I don't think so. Otherwise, you're going to close, no?
Right.
And they will also be affected by it, no? If a school closes because of serious financial problems, technically under the labor code, they're not even entitled to any separation pay. No, if it's because of serious financial losses. If it's just to prevent losses, then they can be employees can be terminated and paid separation pay equivalent to 1/2 month for every year of service. No, but I think employees have to be reasonable also. No? If they demand that the salaries be increased every year despite the tuition income going lower, no? They're killing their own employer. No? So
That's
they
right.
have to face that reality as well. No?
Right. And perhaps another related question to that would be the reverse. Is it justifiable not to increase? And based on your explanation, attorney, the answer would be yes. No?
Yes.
Okay, thank you. There's another question here, attorney, regarding the Safe Space Act from Reynard Sabino. How can the school identify individuals who are protected by this act?
Well, your guess is as good as mine, no? Because as I said, that this is a very new law, no? It came into effect shortly before the pandemic struck, no? Obviously there are no decided cases, no? That is why you have a committee on decorum and investigation, no? That committee does not merely investigate. That committee is also a committee on decorum. No? So I suppose it will have to figure out, no, who are to be protected. No? And the tricky part there is really what constitutes some of the items listed in the law. No?
Yes.
Like, for instance, leering. No? A man in a co-ed institution, a man can when a beautiful girl passes by and he looks at her admiringly, she might say that she's looking at him with lust. No? So there are so many nuances, so many situations that have to be addressed, no, by the committee, by the CODI, no. So even I myself, I would have to sit, if I were in that committee, I would have to sit down with the guidance office, the representatives of women, no, to find out, hey, this type of conduct is totally unacceptable, and then you discuss, and then maybe you come out with your guidelines, no.
All right. Thank you, Attorney. Okay, the next questions, we're going back to tax. From Henry Alarcon Jr. Good afternoon, Attorney. Attorney Binoy Henry Alarcon Jr. here. Greetings from the Consolacion College, Caloocan. There are schools that provide a regular benefit of one scholar for one child of a school employee. How will this be treated in income taxation?
That may be considered a fringe benefit, no? Subject to a fringe benefit.
Okay.
Subject to a fringe benefit tax, no? I am not too particularly. I'm not too sure now, no, about when that will be. When that kicks in, no? There are rules that are different for those in the management side and those in the rank and file, no? But there could be a fringe benefit tax angle there, no? And if it's a fringe benefit, the tax will be on the employee, no? Because that's a benefit granted to the employee.
To the employee, okay.
That is an income to him in a sense, no? Now we've had some schools where that had been a problem, no? So even up to this point, we're trying to fix it, no? To make it as painless as possible to the employees concerned, no? Because like in one school that I handle, we were flagged by the BIR on that, no? So we had to recast our benefits, no, to the employees concerned, no. So that has to be studied, no, and perhaps you'll have to do some adjustments, no.
All right. Noted, Attorney Padilla. Thank you. We have time for a few more questions, but before we do that, I'd just like to recognize our star senders. We did receive some stars. So Ben Zar, 174 stars. Thank you, CEAP from ERL Technology Solutions. Emily Parales Quizam, 75 stars. Rowena Digamon Nakita, 75 stars. Jessely Granza Kule, 25 stars. Connie Paredes Beduya, 35 stars. Thank you everyone for sending in your stars and keep them coming. Okay, we'll now go back to the questions here. From Mary Ann Calanto, good afternoon. How about printing of official receipts? Do we need to get a permit from BIR even if we are a non-profit institution?
Well, that was the subject of a case that I handled personally for a school, no? I was able to secure a ruling from the Regional Trial Court of Quezon City that revenue memorandum circular requiring authority to print receipts from schools was null and void, no? Because it ran counter to two sections of the National Internal Revenue Code, no? Unfortunately, this was reversed by the Court of Appeals on a purely procedural ground, no, not on the substantive issues, no. So that matter can be brought to court again, no. What we advise our clients is that, legally speaking, if you look at Section 238, 239, the applicable provisions of the tax code, you are not, the school, non-stock, non-profit educational institutions are not required to get this authority to print receipts. They can, in the past, they would just use their computer-generated receipts, and that was sufficient. But we are aware that you may have students or clients, who will be demanding official receipts.
Yes.
So we tell them, okay, if that's the case, it's your discretion. You can go and secure this ATP, the authority to print receipts, if you think it is to the benefit of the school. So our position is it's not necessary, but if you are forced to do so by your circumstances, then you can do it. You can apply for the ATP.
Okay. Thank you, Attorney. There are two questions I'd like to present to you, which may be related. One is from Romano. Mr. Romano, thank you, Attorney Padilla, for this very important legal component of any institution. My question is, what could the school administrators in a Catholic school do when it comes to reconciling a legal regulation vis-a-vis compassion and mercy? So legal matters versus compassion and mercy. And in relation to that, a question from Maria Lina Eparwa: is holding a teacher's salary legal because of non-submission of grades?
Well, in our experience, we have said that the not holding of salary pending submission of grades is okay, because the persons who suffer because of this are the students. It's not really the school. So there is an inconvenience on the part of the persons we are supposed to serve. We have a contract with the students. Unless the reason for the non-submission of grades is a very compelling one, valid one, because there could be reasons why the teacher concerned did not submit grades. It could be very personal, it could be an accident, etc.
Right.
Then that has to, you have to go on a case-to-case basis. If the reason is very flimsy, then I guess you should be able to sanction the teacher by withholding the salary until the grades are given out. Now, the first question was more philosophical.
Yes.
Well, I guess you have to, as I mentioned earlier, you look at the circumstances.
Case-to-case basis also.
Yes. I mean, we cannot. There's no one rule, for everything.
That's right. Thank you, Attorney. The next question is from Maria Lina Eparwa. Good afternoon, Attorney Padilla. My question is on important school documents like government recognitions. In the absence of the original copy of such documents, does the affidavit of loss, or does the affidavit, can it be used to validate the photocopies that are kept in the school file? So can the affidavit of loss be used as to validate photocopies?
Well, the affidavit of loss can be used to secure a replacement of the document that was lost. For instance, recognition from the CHED or the DepEd. If there is always a use for that. No, the good thing is that you have a photocopy, I suppose, of the original document. No,
Mm-hmm.
I would think that if you have a photocopy of the original document, agency that issued it, no, can certify that
Right.
that there is a copy of that document on file with them. No,
Okay.
if not, then maybe it's a very old, an ancient document. Then uh, perhaps that agency can also give you a new
A reissue. Mm.
reissue a new certificate, no?
Opo.
Whether it be the DepEd, the CHED, or TESDA, whatever. No?
I see. All right. Thank you, attorney. We'd just like to say thank you to more viewers who are sending stars. Patrick Gilareza, 75 stars. Tyne, 200 stars. Cyan Ramirez, 50 stars. And Grazy Tickman, 50 stars. We're just doing a time check. It's 2:45. And I'd like to end with one final question from Dr. Hasmin Galase. The question is, there are already some schools that will be piloting, face-to-face classes. Attorney, hope you don't mind our asking.
Yeah.
Does the school have any liabilities in case of virus transmission when schools have already opened for limited face-to-face learning? Are we going to be liable for that?
That is a very good question. No? In fact, I'm still grappling with that. No.
Yeah.
Because one thing you may do is make everyone execute waivers, no, that they can come to school, but we cannot guarantee that everybody is vaccinated or that they will not be that the virus will not be transmitted to them. No?
I see. So the school needs to have some sort of protection also.
If I were the school, I would issue that. No, I would make them sign. No? As to whether now there is a question, will that waiver hold up in court? No, later on. No, that is the second issue. No, that is still, subject to interpretation. No, but I would try to give the school some form of protection, no, by a contract with the parents, let's say, of the children, no, or if they are already of age, the student, it's himself or herself, no, that okay, you may already have face-to-face lessons, but we do not guarantee, no, that you will not contract the virus while here. No, you can tell them that we follow all the protocols that the DTI and the DOLE have asked us to do. No, but there's still no guarantee, no, that some accident might happen, no.
That's right. I think all the schools are nervous.
Yeah. If I were the management of the school, I would come up with that general waiver. No?
Right.
Now the DepEd, I think, or the DOLE has not issued any advisory on whether this can be done. No, so it's still a question mark. No.
Okay.
Just as the DOLE issued an advisory that you cannot compel, no, somebody to be vaccinated. Yeah. So I'm not sure whether they will address this issue on waivers, no, for schools that are now thinking of opening, no, or have been given clearance to open, even in a limited capacity.
Well, we hope for those advisories to be released when the time comes. Thank you once again, Attorney Padilla, for your informative sharing this afternoon. I'm afraid that's all the time we have this afternoon. Thank you for answering all the questions that came in. Could we request perhaps a final message from you addressing all our attendees today?
Well, the new normal brought about by the pandemic has really created challenges for our schools. No? On two fronts, the education proper and the administrative side. No? On the education proper, I would call the attention of the schools on problems brought about by social networking, cyberbullying, which the World Bank report zeroed in. No? And then, of course, there's how effective are our teaching models, no? And how effective are our counseling, no? So we have, under this new normal, we have to really counsel not only our students but even our teachers, no?
Yes, attorney.
Even in the administrative staff, no? Everyone has some there are mental stresses related to this pandemic. No? The other is the administrative side, because despite because of the closures, the limited education, we still have to pay taxes and fees. No?
We do.
So that is also a challenge. No? So we, despite the limited activities of schools, we still have to make sure that our accounts are in order.
In order. Mm-hmm.
Yeah, because the regulators, both the national and local, also need money, so they'll try to always look for ways to get something from our schools. No? So that's all.
Thank you so much again to Attorney Padilla for your informative sharing this afternoon. It really is important to keep abreast with updates on legal matters to ensure operational viability, to avoid any potential problems, and to deliver quality education in our schools, given the changing landscape in Philippine education in the midst of the COVID-19 pandemic. So to all our viewers, remember that all PowerPoint slides of all learning sessions will be made available at the CEAP website, www.ceap.org.ph, ready for downloading. And do remember to evaluate one session from today, one from tomorrow, and the Day 5 General Evaluation to receive your e-certificate. Do check out the program tab of our virtual hall. So we will be taking around a 15-minute break, and we hope that you can all join us at 3:15 for our next learning session on the learning environment entitled Promoting Quality Culture in Catholic Educational Institutions. On behalf of our President, Sister Marisa Viri, RVM, and the CEAP Board of Trustees, Mr. Jose Alan Arellano, the Executive Director, and the National Secretariat, Mrs. Christine Marie Lesaca Saludes, saying thank you, enjoy the rest of your afternoon, and see you around. Take care.
Thank you.
Thank you, Attorney.